Great. This is the Senate Government Operations Committee on Thursday, May 2nd. We're in May. And we are going to quickly try to catch up. We are looking at H585, which is an act related to the pension system for sheriffs. And we have draft 2.1 and Rick Sagel with us to talk about the changes that were made in this draft.
Yeah. Good afternoon. Rick Sagel, Office of Legislative Counsel. So yeah, 2.1, I've highlighted the changes from the version that passed the House. And I figured, Madam Chair, I'll just skip to those.
Perfect.
I did a walkthrough last week. Okay.
Yep.
So just a bit of a background. This bill puts sheriffs and certain deputy sheriffs, or gives them the option, to go from their current retirement group, which could be F, presumably F, into group G of the pension system. If you look on page 2 of the amendments, previously subdivision 1I, I'm sure you say that, I guess for 1, said all sheriffs. That language has been amended to say sheriffs who obtain level 2 or level 3 law enforcement officer certification from the Vermont Criminal Justice Council and have not had such certification permanently revoked. So narrowing that option a little bit. Now, this does not mean the sheriffs lose their pension or will be taken out of pension. It just means that if you've had your level 2 or level 3 revoked, then you cannot opt in to this group G. You will remain in your current retirement group. The next change, subdivision II or 2 there, BB, we've added the language at the end and have not had such certification permanently revoked. So this matches the sheriff's definition. So sheriffs and deputy sheriffs must have not had their level 2 or level 3 permanently revoked.
So just, you'll recall that the certification language was already in there for deputy sheriffs, so this just adds it for sheriffs and makes it with.
Yes, and the revocation.
And the revocation
yes,
language.
for both.
Yes.
For both. Okay, going down to page 5. This is just going to be clarifying, the previous language said for all sheriffs, and because now it's potentially not all sheriffs, it's for sheriffs who meet the requirements pursuant to the subdivision that I just referenced. So just removing all in that phrase. And that happens 2 more times on page 6. And towards the end of page 6. Any questions about that? Okay. On page 9. Again, we're just making sure that we're not including people who should not be in this new group G. So the previous language, make sure I had this right. What I changed here, it previously did say sheriffs and those deputy sheriffs. What changed was the actual citation, the subdivision 455. I took off the last parentheses, which was another II, capitalized II. And I think that was that was that was going to reference just deputy sheriffs, and because now I think that was a mistake anyway that I caught. Even with these other changes that need to be updated to correctly categorize sheriffs and deputy sheriffs.
Nice job.
Thank you. All right, and then on page 10. Again, this is the session law, giving them the one-time irrevocable election, ensuring that it's sheriffs who've not had their certification permanently revoked. Also on page 10, deputy sheriffs who do not have their certification permanently revoked, adding that language. And that is the end of my changes to the bill. I'll be glad to answer any questions about it then. My colleague Tim Devlin has a couple of changes as well.
Okay, are there any questions for Rick? Senator Bielanski.
And I apologize for being late. So I have already explained this. My understanding is that you cannot have a mandatory retirement age for anyone who is not doing law enforcement duties, and that is why sheriffs that can't do law enforcement duties can't be included in this. That's what I was under the impression that it was unconstitutional to have a mandatory retirement age unless someone was doing law enforcement work.
That would be a question for the treasurer's office. Honestly, it's very, I apologize, it's kind of specific knowledge. I know that just sheriffs in general, there's no requirements for that, but deputy sheriffs, there might be that requirement that you talked about. That's why they have, if you look at page, it's referenced several times, but on page 2, you have several qualifications for deputy sheriffs. That they perform law enforcement duties, all these things. So my inclination would be that applies to deputy sheriff, not the sheriffs.
Because, as you know, we're not allowed by the Constitution to create qualification for the office of sheriff.
Yes, you should know that.
But the retirement age could be a little bit different. I do want to, I don't know. The treasurer's office would be the best to answer that question.
That makes sense, because the Constitution certainly does not have any bearing on pensions, but, well, I mean, but I think it may on mandatory retirement age.
We can, they're gonna be late, well, they're gonna be back.
Okay.
We can ask him that he was available and now not available, but hopefully will be available again. Okay, any questions for Rick? Okay. Thank you.
Yeah, I'll hang around for a little bit.
Perfect, yeah, that would be great if you can. Tim. So I'm gonna just do a little preface before you go through this. So this second part of the bill was added in the House, related to sheriff compensation. And in talking it through with Tim, I thought adding, and Senator Parsons not here for this, but adding some legislative intent might be helpful.
Should be so proud.
I know.
No, we can't tell her. It's gonna be surprising.
So that's what has been added. Go ahead, Tim.
Thank you very much for having me. Committee. So for the record, my name is Tim Devlin, Legislative Counsel. This modified language will appear at the bottom of page 11 of the bill, breaking to page 12. And this adds a new section. They've been renumbered, so this will appear as 5, but it really should be read together with the following 6. And I'll just read 6 first. This is not being modified. This is in the bill. Senator Hardy said, Chair Hardy said, coming from the House Government Operations Military Affairs Committee, and would modify 32 VSA section 1182 section C, reading compensation under subsection A, that is the full stated salary of the sheriff. The section shall be reduced by 30% for any sheriff whose law enforcement officer certification is permanently revoked pursuant to 23 VSA section 2406. And then the intent section will read, and this is above it, section 5, legislative intent, sheriff compensation. And I should see quickly that this is session law. It is the intent of the General Assembly that a sheriff whose law enforcement officer certification is permanently revoked pursuant to 20 VSA section 2406 shall have their compensation reduced by 30% to correlate with and reflect the sheriff's reduced capability to perform the various duties required to effectively and efficiently manage a law enforcement agency, that is the office of sheriff.
Okay. Other questions? Senator Bielanski.
My question, and is why this would only apply for a permanent revocation. If someone can't do the law enforcement duties even for a short period of time, why would we be paying them to do that's something they can't do?
That was a policy choice.
Okay.
So there are probably practical implications or implications that if you were to pursue that, either temporary or in other circumstances, never having one at all. There's a few different ways to cut that, but this only captures a particular instance.
Yeah, I don't know that it's broad enough to capture an instance in which someone is actually unable to do the full job.
Like temporary
Or if they never have one at all.
or they never had one at all.
Like
We
I,
can certainly ask, we'll have Annie Noonan later, we can see about if applying it temporarily, or if they have a, 2-month suspension or whatever, if we do that. In terms of the requiring them to have one, that.
well, we're not
That's into-
requiring them, we're just recognizing they can't do the whole scope of the job.
Exactly, and that's why we added the intent, to make sure it's clear why we were doing this. And we, as you know, this committee has been doing a lot of work with the 4 county officers trying to come to some language that's workable and constitutional. And so we're gonna hear a little bit, we got some testimony last week from Terry Corsones related to the 2 judge positions, and we're gonna have Judge Stoney talk about that a little bit. And then our state's attorneys and Annie will talk a little bit about that as well. But right now, this is language is limited to sheriffs, so we could certainly talk about if we wanted to expand it. Are there questions for Tim? Do you have to run along, or can you stick with us, or?
I likely do have to go over the House government.
Okay, well, I will be in touch
Oh,
with.
somebody flew up, so I can stay around.
Oh, okay. Well, lucky you.
Stay with us.
Cookies?
Well, we have a container to get back to you for your friend Chair.
Okay, so we're gonna, I think, okay, we have. Is anyone on a schedule that needs to be somewhere else? Okay, cause I know we made you all wait, but, okay. Annie, are you good? Can you stick with us for a little bit? I'm gonna take that as a yes.
I
Okay.
can,
Okay.
thank you.
Thank you. All right, then we're gonna start with Sheriff Murphy. You wanna come on up? So let's first start with the changes in the first section of the bill. And the first section of the bill in general, like, and I don't think we've taken any testimony on this, so if you wanna just start with telling us. And then I think we'll have some questions on the second part for you.
Okay, so, this first section is the page 2 that we're about.
Yeah, well, anyway, I mean, starting on page 1, I think maybe we should start with, because you haven't had a chance to testify just in general on the
Okay,
bill.
all right.
So if you wanna just introduce yourself for the record and
Yes.
tell us what you'd like us to know, why we should do this, and then how you feel about the changes, I guess,
Thank you.
yeah.
Sheriff Roger Marcoux, in Lamoille County, and I am also the first vice chair for the Sheriff's Association. For about 8 years now, we recognized, or I've been working with the treasurer's office on how to get a 20-year retirement option for the sheriff's departments that don't have a 20-year option. And what's occurred through the years is that departments that a long time ago wanted a retirement option, Title 24 gave them that opportunity. But the only thing available 15, 20 years ago was Group F, from what I understand. And with Group F, it was, you're in for a lifetime. Your department is in for a lifetime. So sometime after that, departments began to have the availability of beamers. And beamers has a series of different options. And the Group B option, 20-year retirement availability for it. We were never allowed into Group C except for the state paid deputies. I think there's 25 state paid deputies. So they are in Group C for the Vermont State Police and other state law enforcement agencies. so what we find is that the 14 counties are in various retirement programs. But the departments that were in Group F, that's 30 years or age 62. Quite a few years ago, we found that we cannot compete in recruiting people or retaining people with these 20-year retirement agencies. And you can't really blame the men and women of the sheriff's departments for looking elsewhere when they can cut down their stress time, by 10 years. So I started to work with Treasurer Pierce at the time, and we just could not get around the hurdle of it didn't work at all for Group C. The Beamers, they actually completed an actuarial study, and there was like $4 million deficit in order for us to be able to do this. So that wasn't tenable. So this year was kind of a breakthrough year. Well, actually last year was a breakthrough year for us this year because there was a creation of Group G that was specifically made for the corrections folks who were also a stress job. And in one time we're down 100 people. So there was an actuarial study that was done at that time, a couple of years ago. And in our discussions with Treasurer's office this year, I made a suggestion, could we look into Group G? And I'll let them testify to the details of what they found, but that's where we ended up going, is with Group G. And that is a cost neutral option because each employee is going to pay about 12% of their salary to put towards this towards this option. Right now, I think that we have some Group F employees that are paying 6 point something percent, some that are paying 7 point something percent. The Group C employees, I think, are paying 8.25%, give or take. And so this is a considerable jump. But, I happen to believe, being here for a long time, that this is a sustainable track where I'm not sure what's going to happen with these other departments. So we've gone through the process to get to this point. And what we're asking is that between now and December, January 25, that deputies and sheriffs themselves have an opportunity to meet with retirement folks and have the option to join this group or not. But anybody after January 2025 will automatically be in this group, whether they be deputies or sheriffs themselves. So some of the and I noticed the changes in not, unfortunately, they had the wrong draft and I didn't have a chance to review it. But one of the things that I wanted to make clear is, look, we're only asking for law enforcement or deputies that are doing law enforcement functions, not administrative, not dispatch, just people that are stressed with what they're doing. Just, the same reason that Group C was created a long time ago. And my understanding is this is going to be a one-time shot. So, and the sheriffs themselves, all the new sheriffs after January 2025 will also be into this group. And hopefully down the road, we're going to be able to we're not asking for this end, but to get everybody into the same retirement program with the sheriffs.
Yep. So this move would allow sheriffs they would have to contribute more to their pension, but they could retire sooner because they would have a full pension sooner because of their contributions being higher. And the logic is that because they work high stress jobs, an earlier retirement is
warranted perhaps. Is that what I'm
Yeah,
hearing you
I've
say?
been here, as you all know, I've been doing this for 44 years, and that's way too long.
Well, your institutional memory, however, is incredibly
It's
invaluable. I
amazing
wish you
because
could
my
be
other
paid on
memory is
that.
gone.
But if you were paid on your institutional memory, Roger, you'd be wealthy.
But that is the idea, is that we want to, particularly now, nobody knew what was going to happen with the courts after COVID. Well, courts are busier than I had imagined that they would be. So, we can't underestimate how serious it is to train somebody to conduct court security. Because the staff and people using that building, everything depend on those folks. So, what I'm hoping is that this is gonna be a good career move for some people that don't want to go to maybe to the 13 or 18, 17 weeks, sorry, police academy, but could certainly do that court security or court transport as a per diem. So we're just trying to keep the people we have, but right now we're kind of a pass-through feeder agency for municipalities and the state law enforcement agencies.
Okay. And how about the changes to the section? You and I discussed them before you saw them, but.
Yes, so I don't have any issues with adding the sheriffs to the level 2 or level 3. I've not discussed this with the group, but I've been empowered to testify. And I think that I don't have any problems with, I understand, having a sheriff who has a level 2 or level 3 certification eligible for the. So with respect to section 5 and 6, so that was added during the House process of this iteration of this bill. And it sort of mirrored what I assisted Annie Noonan this summer in the Act 30 language and everything, and Annie had picked the 30%, judging that, okay, if you're level 2, that's worth a 10% reduction. Somehow the legislature said that was acceptable. And so she and I agreed at the time. We didn't know we were going between, is it 30%, is it 50%? We don't know. And we may not know until it's challenged in court. But I certainly think that it's reasonable that someone who takes a sacrifice for them and their family of going away for 17 weeks to the police academy and receiving that extra training, I look at it as we do for folks with a master's degree as opposed to people, with an associate degree. And I think it's reasonable that there is some recognition of that extra effort on that person. So, the law enforcement function is very, very important in the sheriff's department. Because even if you're not the person that's out working a case or working the road, you're the person supervising that person. If you see some kind of a policy violation or something more serious, you as the agency are responsible to ensure that a proper internal investigation is conducted on that person, and you have to know, what that process is, and you have to know right from wrong. So I personally think that there should be some differentiation there between a level 3 and somebody with no certification. If you have somebody that's never done anything wrong that decides to run for the office of sheriff that has no certification, but they have a lot of management skills or what have you, do you treat them the same as you do somebody that has lost their certification through an Act 56 process for some kind of malfeasance or wrongdoing. So, you know, these are all questions. I have my own thoughts about them, but it's work for you all to make that decision. So,
And this language does say that under section 6 is that the law that it's reduced by 30% if their law enforcement certification is permanently revoked. So this is not that they've never had one, it's that they had one and had it permanently revoked.
right.
Yeah. And I guess, you know, you and I have talked a lot trying to figure out what the right percentage is. And for some sheriff's offices, it may be 30% is right. And for others, the law enforcement duties of the actual sheriff are, excuse me, we should have one, maybe 2 bills. Okay. Thank you, Melissa.
Thank you.
Maybe a higher percentage than 30%.
Could be, like I said, you know, some departments, some of the things we're mandated to do is transport prisoners to courts, to oversee transfer of property or whatever, the temporary relief from abuse orders, and to it's not law yet, but to provide, well, maybe provide security for the courts and sort of civil process.
Yeah.
Serving civil process you can do as the rest of those things you can't. So, you know, that's a fact. It's just a question with that, how do you assign a value?
Yeah. Yeah, okay. It seems to me that it's more than 30% of the job based on what you just listed.
It certainly is in my operation.
Yeah.
Yeah.
Yeah. Senator Yoski.
Yeah, no, I hear you, in, you know, the question of, or the sort of point, really valid point you made, that it is really different to lost your certification for malfeasance versus never having gotten it. Where I don't think it is any different, though, is neither one of those people can do the law enforcement portions of the job.
Agreed.
So how much is the administration worth is sort of what we're asking.
Like, I do hear you, certainly, you know, and if someone gets elected and doesn't have it, they certainly could go get it.
That's right. They could even go get a level 2 certification, go to the academy for 2 weeks and do the 60 hours or whatever it is, field training, and then they would have a law enforcement certification from the academy. The thing about, you'll have a lot of people, and I've had them, and I was a level 2 certified officer for a year and a half before I ever went to the full-time academy, and I thought it would all. But besides learning about a whole bunch of different things about law enforcement is the discipline that it takes to grit your teeth and get through that training. And if you can do that, it's a little bit, it makes it a little bit easier to deal with some people that are not pleasant to deal with from the outside, where you need a lot of discipline. So, and I'm not saying that's the case in every case, but the discipline to have to go through that training is something not to be taken lightly.
Yeah. Yeah. Go ahead.
You know, I have kind of a technical question that is maybe for you, Sheriff Marcoux, or maybe for one of the drafting attorneys, and just the way I see this sort of drafted being explicit to level 2 or level 3, is there a level 1?
There is statutorily a level 1 that's on the books that the academy is supposed to come up with. They have not done so,
Okay,
and that's been a few years, but level 1 is, so level 2, you can do traditional law enforcement. Sheriffs use level 2s in a certain way. The municipality may use a level 2 as a augment their patrol force. You know, so they'll have them do patrol, certain things they can't do, but they can certainly help cover a shift. Level 1 is really meant for security, court security, detail work, some of these special details that sheriff's departments need to do because there's a need in the community and because the sheriffs need to generate money to create their budgets. So that was the impetus behind level one. But that has not yet been put in place at the police academy. And I think that part of the reason for that is gonna probably take sheriffs to come up with their own training curriculum to help out and do that.
My follow-up to that is if there, and I certainly understand that your crystal ball may not be working today, but I'm wondering if you envision any future where there could be a level 4 or a level 5, if the certification, as we think about law enforcement modernizes, if there might come a point where we feel additional.
Well, it's the first time I've been asked about that, but you take specialized teams. Right now, I'll use the state police for example. We have a traffic accident with injuries. And so we'll ask for a specialized team to come out to do use lasers and what have you to create a diagram of the scene. Major crimes unit, that's the cream of the cream of investigators. Like they may investigate cold cases or whatever. Maybe something like that. I don't.
Yeah, so, but it could, and then my question is for the committee, or is if it makes more sense for the language to read level 2 or higher. So it holds for the possibility that there could be a future day where there are actually higher certifications. Because you know how I like lists.
Yes.
I was gonna say
Are
tiers
you-
too, how would you like tiers?
Where are you talking about specifically?
In both of the sections where it references, they're at the beginning. Page 2, where it says sheriffs who obtain level 2 or level 3 law enforcement officer certification, it's line 10. I wonder if it makes more sense to encapsulate anything that could happen in the future to simply have that read level 2 or higher.
What do you think, Rick? Does that?
It doesn't yet exist, not to say that it couldn't exist.
We can always add that.
I think it's pretty obvious to know what we're talking about if you say higher, that would include 3 and a 4 and 5, if those were to exist.
Yep.
So I think legally you're okay
Legislature.
if you want to use that language.
Okay, let's put a pin in that and we maybe have other people. Those location. You're right, and showed up in a couple times,
Yeah.
a couple of ways.
Certainly.
But that also for the I guess in the language in section 5 and 6, it just says law enforcement certification. It's not specific to levels. It's any certification if they've had it revoked. So, okay. I guess we're gonna also put a pin in the 30% for now too, and see if we can come up with a better number, or if that's the right number.
I also would love to put a pin in the conversation about if it should only be if it's revoked or if they just don't have one.
Okay,
We also haven't talked about, maybe you did talk about suspended,
I brought that.
yes, Senator Vihosky talked about that, and
because we've had a couple of suspended cases too.
yeah,
I feel like if we're reducing pay, it should apply in any instance where I can't do the job.
so Annie, I hope you're listening, because one of our questions for you will be the feasibility of doing something like that, so.
I am
Oh.
listening.
Great, thank you. All right, I've noted these. And Roger, are you able to stick around with us? Okay, perfect. Thank you so much for your time today. I think I'm gonna actually skip to Judge Zonek's speech because I think it's sort of, and Judge, I think we were, so as I mentioned to you beforehand, but also, the sections 5 and 6 of the bill are sort of part of our contemplation about county officers, 2 of whom are judges. Or one of whom is a full judge and the other is a sort of is an assistant judge. 2 types of judges.
No, but 3 judges altogether, because there are 2 assistant judges and 1 probation.
Yeah, but types of judges, 2 different types of judges. So we got some really good testimony last week from Terry Corsones about what the courts do when somebody has been disciplined by the Judicial Conduct Board and what might happen to them if they are told you can't be a judge anymore. essentially the equivalent of losing their law enforcement certification in the world of judges. So I'm just wondering if you could just walk us through that so we kind of understand and what makes it different in the judiciary versus the executive branch.
Okay, a shot. So Tom
Okay.
Zonay, Chief Superior Judge. The Supreme Court has the disciplinary authority over all judges in the state, whether they are superior, whether they are magistrate judges, assistant judges, or probate judges. The difference between the three categories I mentioned first and the latter two is that the latter two are elected. And so they're the elected judges, they're county officials. One of those two categories has administrative responsibilities also. And that would be the assistant judges. When a judge is accused of misconduct, there are provisions within the rules of disciplinary control of judges where they can be temporarily suspended. That's a suspension from their judicial duties. I would note that in 2009, the Vermont Supreme Court, in a case from Windsor County, I see two Windsor senators here. It was
Your senators.
there was an assistant judge in that county who there were allegations that he had engaged in conduct that was improper relating to several things, one of which was in contracts, where he was on a board of an organization and the assistant judge negotiating it. But what the Supreme Court did in that case was follow the recommendation of the Judicial Conduct Board, and it actually said that not only does the Supreme Court have the authority to discipline for what we'll call the adjudicative functions and suspend, what they did was they suspended him for 6 months. Not only that, but he was suspended from his administrative duties too. The Supreme Court indicated that that fell within his authority, so the
That's
Supreme
because of the
Court.
contract bit though, right? Or sorry. It wasn't because of his conduct, it was because of the contracts.
Well, it's because of the conduct that there was issues with the contract that was negotiated where he was on both sides. There was also issues, I believe, about allegations about a sign being stolen and letters to the editor.
There were many.
There were more than one. What the court focused on though was that we're not just suspending you from being a judge in court.
Yeah.
You're suspended from your administrative duties too. But the key is it was a suspension. You saw within the past several years, we had an issue with one of our probate judges in the Northeast Kingdom where the individual there was a situation where allegations were brought by the professional responsibility in the individual's capacity as an attorney. That led to a suspension as an attorney, but it wasn't final. That led to a suspension as a probate judge, but that was with compensation. It wasn't until the suspension became final that it was a suspension without compensation.
Okay.
And so
So when it was temporary, it was with
it
compensation?
was with compensation.
Okay. Okay, but the big key difference, or a key point is that you were able to suspend, or the courts were able to suspend the salary, but not remove them from office.
What happened in that circumstance was when he was eventually suspended, I believe it was in the fall, and the election was coming up.
Yeah,
At that point, we had a suspended judge who was no longer collecting a salary. But we had a position that the governor couldn't fill
right,
because he was still in that position. The Supreme Court couldn't remove him and say, okay, that position is now vacant. That would have been impeachment.
right,
So we had that position and at that point, we were able to utilize other judges from around the state, but we had prior to that, under the rules, he had been paid
yeah,
for a period of
Okay.
time.
all right. Senator Clarkson, did you have a question?
Yeah, no, I wasn't clear on that, so his pay wasn't suspended.
His pay was not initially,
His pay
it was in, I believe in May.
Yeah,
When
was.
it would have been May or so when the Professional Responsibility Board said there's this issue. And they issued a decision, and that decision was public.
Mhm.
At that point, the Judicial Conduct Board got involved. The Supreme Court issued a temporary suspension in accordance with its rules. But that temporary suspension in accordance with the rules was with pay. It was in the fall when it came out that he was the decision by the Professional Responsibility Board suspending him. When that became final,
At that point, under the Supreme Court rules, I believe it's rule, disciplinary control, rule 5, subsection, rule 6, subsection 24. Then it became, it shall be a suspension without compensation at that.
But they were able to do that, but not initially, not for the.
Not initially, it does not happen, that's correct.
So I would love to be able to, should make sure we can clarify that in this bill, that suspensions were included.
For the sheriffs or.
Yeah, and I don't know, at this point in the game, I don't know if we're also wanting to include.
If we can, we
Yeah.
could, but,
Be great.
I don't know that we can include the judges because the discipline of judges are the purview of the judiciary.
But the pay we could do because they didn't.
Well, it's only because that's the rules that are in place, but the judiciary does address, the judiciary has the comprehensive rules for disciplinary control of judges. And they address when, under the rules, it's appropriate to suspend someone's pay and when it's not.
Okay,
When they're paid by the state.
yes,
The court has that in mind, I'm sure, when it sets the rules.
so we have to be careful what we tell the judiciary to do. My attorney,
We're always trying to be.
Mr. Devlin tells me that all the time.
Stop getting cookies. We do.
Go ahead, Senator Bukowski.
So that person held that office, you had to move judges around. What burden did that create for the courts?
It creates a significant burden, especially in the probate court, I would say, because the probate judges are not all compensated the same. They're not, essentially the way the probate court judges are compensated is there's one judge who is viewed as a full-time compensation model, and that's the Chittenden judge. And I believe when they redid this back, when they went from more than 14 down to 14 probate judges, and they redid the salaries as part of unification of the courts, they came up, the legislature came up with numbers as far as, okay, your position is going to get paid X, Y, and Z, and some translate to 2 out of 2/5, 2 out of 5 days, 3 out of 5 days. And so it's difficult when you look at a probate judge from one county and say, well, we need you to go and do work in another county, even though you're not getting paid full time. You're getting paid part-time and you're allowed to practice law and you planned on that. And so what we did, in order to be fair, was we had to bring judges in, we had to pay them. We paid the judges from the other counties who had available time within the structure of their pay. If they're based on the 5-day work week, we would say, okay, what I would do is especially assign people and say, you're authorized to work up to 5 days. And so the judiciary had to pay extra money while we were paying a suspended judge. That ended when the judge became when the salary stopped, with the compensation being stopped under the rules when the suspension became permanent.
The double pay ended,
Correct.
but the needing to
The need,
call on other
that's correct,
judges.
the need to rely on other judges continued until the election. And the new judge came in
Only
at February.
do something about this. So I have another question for you about state's attorneys, and I'm gonna ask Annie about this as well, because they're in a funky category where they're partially overseeing, their discipline is partly overseen by the judiciary. We just saw this in Addison County.
They're lawyers.
Because they're lawyers. So can you explain the judiciary's purview over state's attorneys?
The professional responsibility program board has the Supreme Court has the professional responsibility program that oversees attorney discipline.
So
If they're lawyers, it's still required.
well, so if a state's attorney had, so we just had a state's attorney that was temporarily suspended from practice or had her license temporarily suspended, her law license, I believe.
Right.
And she was continued to be paid. If a state's attorney had been permanently, does the judiciary have the authority to suspend a state's attorney's pay?
The judiciary has the authority to suspend them from the practice of law.
Okay,
We do not get into, it's, if the attorney was not a state employee and they were a private attorney, we have the same ability.
Okay.
Suspended from the practice of law.
Okay.
We wouldn't be able to say the compensation side, that's not something that would fall.
okay, so in the case of a state's attorney that was permanently suspended from the practice of law, they would still be the state's attorney, because you can't remove them from office. And they would still be paid because you don't have the purview to remove their pay. But they would be limited in what they could do in their role as state's attorney because they couldn't oversee cases or supervise attorneys who were doing cases for the court. Is that correct?
That would be, the court has only the authority to say that they can or cannot practice law. We don't have the ability to say.
And this is a stupid question, but practicing law is the work that they do before the courts and doing the investigations for their cases and advising their clients.
Practicing law is certainly one of the aspects of the state's attorney position.
Okay.
Yes.
But they also manage.
Well, yes, yeah,
Like
there
the
is some
sheriff, they also
percentage, and this is the tricky part with both sheriffs and state attorneys is trying to figure out what that percentage of is of law enforcement and practice law. Senator Yoski.
So 2 questions. One is going back a little bit, and it's a question that you may or may not be able to answer, but why didn't you impeach the assistant judge that was holding that position and forcing you to do all of that?
Impeachment is a legislative.
Oh, so we would have had to impeach, well,
Start in the House and come
Okay.
before you as the vote as the jurors.
well, I guess I'll have to find out.
And I don't know why we didn't choose to do it at that.
We were not in session. It was in the fall. And by the time we got back into session, they that somebody had already been elected to replace them. And it was just a matter of
Not elected.
it was, I believe, October, if I remember.
It happened, I remember actually when I first read the decision from the Professional Responsibility Board. It was May of 2022. I was in Chicago. So that's how I remember, I was in a conference and I looked at my phone and I went, oh, I'm gonna step out on this one. So I stepped out, read it, and then things happened. It was not until the fall. I don't
Right.
remember exactly, but then the election came up
Yeah,
Okay.
and
it was just, again, the timing of.
Yeah. My
Yeah.
other question is going back to judges and state's attorneys. So we set those salaries in statute. Why would we not be able to set parameters around salary reductions in a statute?
I would say that's a question for legislative council in
Okay.
terms of that, because I'm aware that that's a question that comes up and there's apparently a number of differing views on that, which if there's something done, it could come before the court, so I'm not in a position to answer that.
Understood.
Okay. Are there any other questions for Judge Zoney? And we do have Terry's written testimony. I believe it's on our website today and last week, which explains this too and has helpful links. Thank you.
My
It's
pleasure.
very helpful.
Do you want me to take the container of cookies? The empty
We
container.
have 2 empty
We have
containers.
two. Are you leaving right away?
I will be, if it's okay, I'll head out. And
I think we're done.
Okay.
Thank you.
is it required that I bring them back full?
Yes.
Oh, we don't even have to ask. Terry just brings cookies every time.
Yeah.
No, I'm convinced Terry is monitoring every committee in this building because I said in this committee, I had asked you for cookies. And the next day she showed up in judiciary with cookies.
Yeah.
Mrs. Fields has nothing on her.
No.
So Tom,
So-
the first one is plain, the bottom one is pulling.
Okay, that's great. Well, thank you.
But until I
Thank
owe
you.
her a thank you note because she did come for my birthday.
Let her know. Have a
Thanks,
great day.
Judge Zoney.
Take care.
Take care. Okay, I'm gonna go to, well, you're Tim Duggan, right?
I am.
I'm sorry. Are you still on the timeline or can?
I'm
you-
free now.
Okay,
I was,
can wait a little bit
I can
longer?
make this.
Okay, thank you. I appreciate you coming over here. I'm gonna go to Annie. Then we're gonna stay with this theme. Hi, Annie. So.
Good afternoon, senators.
Good afternoon. Thanks for your patience. Well, for
Oh, no
every,
worries.
you've heard the conversation of both sheriffs and state's attorneys, which are under your jurisdiction or whatever your office purview. And I'm wondering, we've had this conversation about the 30% and where that came from and if that's the right number. And then also similar questions for state's attorneys. And then the question of whether the provision should be, have they earned the level 3 or have they had level 3 revoked? So I'm wondering if you could weigh in on any of those. And then, of course, you haven't yet had the chance to testify on the bill as a whole, but I believe you're supportive, but just wanted to give you an opportunity to speak to that as well.
Thank you. For the record, Annie Noonan, Department of State's Attorneys and Sheriffs, Labor Relations and Operations Director. Thanks for inviting me in. So very quickly, yes, I do support the bill. Roger Marcoux, Sheriff Marcoux and I had many, many meetings over the years with then Treasurer Beth Pierce, trying to address this issue so that the sheriffs were not just the training ground for people who would come in and then quickly leave as soon as they were able to secure a job with a better retirement system. It's been a real challenge. And it impacts the local towns that are supporting and counties that are supporting some of the sheriff's operations. So it's been a real challenge. I think it's well worth it. I was really pleased that it was actually the treasurer's office, the retirement division folks, who had suggested Group G. It really makes sense, and I always love to be able to sit here and say, and it doesn't have an impact to the budget, because the cost of that is borne by the sheriffs. And getting into Group G, the establishment of Group G was also a very positive thing for state government and state employees. So congratulations on having thought of that. But it also really does make sense for the sheriffs to go in that direction. So yes, I fully support it. So to the questions, and if I can, I might skip around a little bit, but maybe this will be helpful. When we submitted the report for the S17 Act 30 report, we specifically identified that we said that the statutory provision of 32 VSA 1182B reduces the salary by 10% for someone who does not have a level 3 certification. And we basically said and pointed out that the statute was silent on a salary reduction for a sheriff who doesn't possess any law enforcement certification. My theory, and I've shared this I think before, is that I think that was somehow overlooked. If you think that, consider the fact that a prior legislature considered that issue. If you're not fully certified to do the job and you're less than at level 3 or a level 2, we're going to institute a 10% reduction. I'm not sure that they who knows the history? It may have just been a blip and they forgot to think about, or maybe they thought about it and it didn't get enacted. But I think that I'm going to say that it just was a blip, that they didn't think about what do you do if somebody is not level 2 and they have nothing. So we recommended in that report 30%. There was nothing scientific to that number. I want to be really clear. There was no methodology, no study on that. It was really a conversation about, do we have any sense of how much of a sheriff's job is administrative versus law enforcement? And without having done the work to determine that, we really just said, well, 30% seems like a number that we'll put in this bill, and we know it will be discussed further. So it didn't have a scientific basis. I wouldn't pretend it did. But I do think that there is merit in the conversation of someone who, and I see you're looking at the issue of, what if somebody comes into the job with none? What if somebody has it and then loses it? Tomato, tomato. I'm not really sure. If the conversation is you can't do the job, fully do the job without certification, then should there be a reduction? So I want to point out a couple of things that, and I think Sheriff Marcoux may have testified to this, but there are things that a sheriff who does not have certification can't do. Powers of arrest. The reason that we have certified officers go to relief from abuse, retrieval of property, where we have them go to that scene, is because we sometimes presume that there could be some bad behaviors when somebody's trying to get their property, out, and the other party doesn't think that that's a great idea. So we want to keep the situation under control. Roger mentioned court security. There are things that a sheriff can't do, a non-certified sheriff can't do, and they can't supervise. So if a sex assault case comes in from the field, they can't supervise the work of the deputy sheriffs who are able to do that work. They can't supervise that work. There's things they cannot do that are important role of the sheriff. Many sheriffs are doing a tremendous amount of law enforcement activities on a daily basis. I think that's just a fact. the question that came up, what I was doing sticky notes to give myself reminders of things to say that I want to share with you. So right now, you know that the statute doesn't require a person to be a sheriff. I mean, a certified officer to be a sheriff. Similarly, it doesn't require them to be an attorney to be the state's attorney. I'll get to the state's attorneys in a bit, but the temporary suspension piece, really does put a burden on both operations, whether it's a sheriff or it's a state's attorney. They may still be doing administrative duties, but there are many things that they can't do. And that is a burden, and it becomes, in many ways, a financial burden. So let me shift to the conversation, if I can, about the questions that came up around the state's attorney. Again, saying, if the statute doesn't currently require them to be an attorney, but let me point out a couple of things. We have two offices as state's attorneys where the only attorney in the office is the state's attorney. That is Essex County and Grand Isle County. So if someone were to run as a non-attorney and win, we would then be paying that person a salary. And in this case, the salaries for those offices are about $100,000. Right now, it's $99,100 for those two part-time offices. We would have to find or contract for legal services for those offices. So we'd be paying a full salary. Then I would have to go out and find somebody who can handle those cases because they can't do those cases. Most of our state's attorneys are carrying a caseload similar to what the deputies are, which is about 365 cases. They are carrying very, very high caseloads themselves. So it would be a huge, huge burden. We have three offices that only have two attorneys, the state's attorney and one other. So again, play that out again. If one of them, if the state's attorney was not an attorney, that office would again have would only have one attorney who would be handling thousands of cases. So it really would be a challenge for us, and we can't then say to the rest of, our state's attorney staff, well, go up and handle all the Essex County cases, go handle all the Grand Isle cases, go handle the Orange County. Just can't do it. So, I mean, could we do it? Yes, but would people be quitting left and right? I believe so. So that's a real challenge in this whole thing. So, logically, I think to myself, a state's attorney should be a licensed attorney in the state of Vermont. A sheriff should be a certified law enforcement officer in the state of Vermont. That's where we go with this. We've not done anything. If you said to me, can you tell me what the percentage of administrative duties are for a state's attorney versus legal duties, like in the courtroom directly? I would say, I've never done that. We've never looked at that as a study. I'd be happy to do that and try to get that together for you at some point, if it gets to the point where you're kind of considering this also for the state's attorneys. Not having a certified state's attorney, a licensed state's attorney, we would basically be happy to pull that data together. I don't have that at the top in my head. But I can tell you, if it was helpful, I could have our IT people run the numbers of actual cases that each state's attorney is currently assigned to them. And that may be instructive to kind of see what would you do with all these cases. Let's say it's Sarah George, or it's Ian Sullivan, whatever. How many cases are they handling that we would then have to distribute or get somebody to cover? So
Right.
Happy to do that for you. But I think that the important thing of, there's this, I refer to it as a backstop. When you have a sheriff who has, if they were required to have law enforcement certification, the backstop for, I'm going to just say bad behavior. I'm just going to use that term if I can. For bad behavior is, as a sheriff, would be the Criminal Justice Training Council and Act 56. There's something there that says, no. Similarly, for a state's attorney who has a license in the state, it was licensed to do law in the state of Vermont, the backstop is the Professional Responsibility Board. Some people call it the Professional Conduct Board. Again, another backstop for bad behavior. Those are, in essence, it's almost like, it's just that second check and balance. I think that's really important.
Yeah,
So I feel like, you know, it's unfortunate to say, but we've seen problems. And I feel like we've seen them. I share the frustration. You know, we've saw the situation for the Franklin County State's Attorney. We've seen the recent suspension for the Addison County State's Attorney. We had the Addison County Sheriff. We've had, you know, I mean, there've been, I don't need to keep going. I think you all, you know the situation. So doing something that holds people accountable for good behavior, ethical behavior, responsible behavior, in my view, is the right direction.
well, Annie, thank you so much. One question, and then I'm gonna go to Senator Dehosky is, so on the temporary suspension, if we were to contemplate a salary reduction, for, say, a, 1 month long suspension, is that feasible to do just from a technical and administrative standpoint?
I would have to consult with Beth Fastigi's staff, because the salary is embedded by statute, as you know, and I think it's just an automatic, they take that annual salary divided by 26. So I'd have to figure out if we could, I'm sure can it be done like mechanically? Probably. I've never considered it. I wouldn't know how to do it. We would have to talk to Beth's staff.
Okay, mechanically. Roger wanted to weigh in on that.
Roger Marcoux, if a sheriff is suspended,
You can stay seated.
oh, thank you.
It captures you right there.
If a sheriff is suspended, my belief is that immediately the high bailiff becomes the sheriff until that sheriff can fulfill their duty. So you'd have to pay the high bailiff as well.
So there's a fiscal
Oh, there's a big fiscal
impact enough to have to pay two full salaries.
It's like having to pay the two judges that like Judge Sone was
Yeah.
explaining. Yeah. All right, Senator Dehosky, do you have a question?
Yeah, I have a couple. So the current statute that reduces the statutory salary by 10% if someone doesn't have a level 3, that's for anyone that doesn't have a level 3. It's not dependent on whether or not they lost it or they never got it. It's just you don't have a level 3, that you're reduced by 10%.
Correct.
Okay, thank you. In an instant, and I recognize the instances that you gave with the offices that have only one state's attorney are sort of like just to think about. But we have had a couple of instances where state's attorneys were not able to practice. What impact did that have on the backlogs?
I would say probably substantial. Even if I can give a real life example right now, even with the Lamoille County situation. So when State's Attorney Todd Shove stepped down and back out of that State's Attorney role, his second in command, and there's only 2 attorneys in that office, the State's Attorney and the deputy. So the deputy was asked to step up as an interim, was appointed by the governor as an interim. We hold that position vacant behind so that if in fact that person who steps up doesn't get appointed, they have a job to go back to, right? Because they, why should they have to relocate their family wall? So now, could in that situation, could that interim state's attorney say, go ahead and backfill my position, I'll roll the dice and take my chances? Yes, they could. That's up to them. But we have had basically a policy that says it's not fair for somebody who accepts that extra responsibility and role to then not have a job to go back to. So right now in Lamoille, that's a problem. We have basically have had a long-term second spot vacancy, so to speak. Todd Shove, the former state's attorney, has a part-time, he's working part-time for us on some of our limited service money, just basically helping. But if you ask me, that office is now a full position down. So that does that help, Senator? Like so the backlog, I looked at, so guess whose county has the biggest backlog? Lamoille County right now, today.
Yeah, I would assume that.
Well-
Yeah, I would have assumed it was the case, and I would imagine that it would be a bigger impact in state's attorney's offices with fewer people, just because there's less people to spread out that extra money to, and so, and we know our state's attorneys, I mean, caseloads of 300 and 400 are absurd, so they're already underwater, so I appreciate you just verifying what I assumed to be the case.
Correct.
I would like to vote on it today if possible, but we will see, and we still have another bill, I'm sorry, Annie, I
I'm not
just,
gonna wait for the other
we still
stuff.
have another, the animal welfare bill to vote on today as well. We're gonna hold on to 702 until tomorrow, but, I'm sorry, we were long on the floor and we are running out of days. Okay, Annie, if you're able to hang out, maybe, just in case we have further questions, I do wanna get to our last two, witnesses. So we can maybe finish the conversation. Do you have one more thing to add? Go ahead.
There was, and I think Sheriff Marcoux, it may have been answered and I may have missed it, but the question came up about the sheriff, and I made a note to myself that the reason that the sheriffs could not be put into a mandatory retirement situation in any
Oh,
plan
right, yes.
was because the court said that can't happen because they're elected officials. Roger can speak on that. I think it happened. I think that decision came out 2 days after you became a sheriff, didn't it, Roger?
3 months after I was Group C, Roger Markey again. When I first took the job, Governor Dean appointed me and said I was the first sheriff to be in Group C. 2 or 3 months after that, I was kicked off the island, so to speak, back in the Group F, because you cannot force an elected official to retire.
Okay, so in group C has a mandatory retirement. This group does not.
No, it isn't.
Okay, so that's
Okay,
why.
that's what I
Okay.
was.
All right. Okay,
Thank you.
Annie, that's really helpful. We're gonna hear from Steve Howard because I think he has a request, and then I want to hear from Tim Duggan because I want to hear what your thoughts on the request we're gonna hear. So, we're behind schedule, so we are gonna try to do 6:26, but we're pretty far behind schedule. So
So-
welcome to hang out here.
You're welcome to go have fun.
Or you go have fun or hang out either way.
Thanks.
Okay, Steve, and you had sent me something, I don't know. I'm sorry, we're not quite ready, so I'm sure you have better things to do. Can we just have Olivia ping you when we're ready?
Sure.
Perfect, thank you. So Steve, did you submit something in writing,
I did, and I actually have real
paper copy?
paper copies for everybody.
I can, Mr. Howard comes prepared.
I do.
He's Mr. Group.
There you go. Thank you, Madam Chair. For the record, Steve Howard. I'm the Executive Director of the Vermont State Employees Association. And I am here to request some additional language for this bill that would allow for some similarly situated classifications in our military department to be added to be given an opportunity to have a one-time election to be added to Group G. The positions are very similar to correctional officers. They are security operations supervisors, force protection officers, assistant force protection supervisors in the military department. They do work in a 24/7 capacity. They are required to carry an additional 35 pounds of gear during the time that they work, providing security for our military department.
It's like being pregnant.
Right. 24/7, 24 days for the rest of your life. That's our request. And I feel like
What group are they in currently?
they're Group F, I believe.
Yeah, it's, nobody likes Group F.
Yeah.
Can you just answer a question?
Well, Senator Bukowski had her hand up first. Then
What
I'll
is
go.
this department?
Well, I'm about to ask that question. These,
I didn't know
Steve,
these.
are the civilians that guard our National Guard bases.
Right. Yeah,
Oh,
Yeah.
good, because I didn't even know they were that.
Yes.
yeah.
I didn't even know
Observe on its face. There's civilians guarding the military.
Who oversees this?
You know,
What are they?
Military department,
Did you know
it's a good question. I don't know if it's the adjutant general.
But that's National Guard.
Right.
So that's not the Vermont state military.
That's the Vermont National.
but these are state employees.
These are state employees.
Okay, interesting. Okay,
many?
well.
How-
We'll put a pin in this too. Are there other questions for Steve, Senator Clarkson?
How many of them are there and what would it cost?
So there are 31. And fortunately, the treasurer's office may have some specific numbers for you, but having spent a good part of my life working on the design, construction of Group G, Group G was designed to be cost neutral, much to our disappointment. But it is nevertheless the reality that the contributions from the employee are much higher than
12%.
Yeah, very close to 12%. So
Okay,
And is there a retirement piece with this too?
they would be eligible, like a correctional officer, they would be eligible for retirement at age 55, but not required
After 20 years, which is.
after 20 years, right? At age 55.
okay. All
So
right,
they have to be both no younger than 55 and have served
20
20 years. So if they, at their 20 year are only 45, they still have 10 more years.
So
to
now
go.
I got it.
Okay.
And they could choose, well, now the Group C folks could choose to go to 57, but they could choose to go longer than age 55.
because there's not a forced retirement age.
It's not a forced.
Start at 35.
Yeah, I was just recognizing that a lot of people start their jobs before 35.
I think for the reason that Senator Hosty. I've been practicing while I was idling in my car. That's what I was practicing.
Yeah.
You can't force somebody. You can't have a mandatory retirement age for somebody other than somebody in a law enforcement position.
That's not true. Fairly. Not your job.
Yeah.
All right, Senator Watson.
Thank you. Do these folks have law enforcement certifications like level 2 or 3?
They are not sworn law enforcement officers. They're comparable to correctional officers.
Okay, cool. Thank you.
Right. Thank you so much.
Tim.
31 of them. I didn't even know they.
I learned about these people a few weeks ago.
Hi. Have you testified in here before?
I don't think.
I think so. Okay,
so.
I didn't think I knew you when you came in and I was just guessing you were 10. I'm Senator Ruth Hardy from the Atkinson District.
Olivia Parker, I'm making case. Tony Vinoski, Chittenden Central District.
Hi, I'm Rebecca White. I'm one of the Windsor County District Senators.
Bob North, Franklin County.
Ken Watson, Washington District.
Allison Clarkson, Windsor County District. And I feel like we've seen you on.
Yeah,
Zoom.
you're
I've seen
familiar.
you on Zoom in other capacities, many years.
I don't believe I've been in this committee, in this binding,
Yeah.
I've been.
Well, welcome. Thank you for, why don't you introduce yourself for the record, and then I know you might have some maybe sort of background comments on the bill, and then you heard a lot of our questions, and I also would love your, what your thoughts are on this and feasibility and cost, et cetera.
Thank you.
Okay,
It's the record, Tim Duggan, I'm an Office of State Treasurer, I'm the Director of Vermont Retirement Systems. In previous capacities, I was General Counsel in the Treasurer's Office for a few years under the former Treasurer. So that's where I did a lot of work on some of these matters before. So I thought I'd start with the original House passed bill that we've been working on with Annie and with Sheriff Marcoux, and that has been a really, I think, a successful project. So I want to say, ever since I joined the office in 2017, at least, there was this issue that the sheriff's offices in the state system faced where their deputy sheriffs did not have a 20-year retirement plan. And the discussion at that point really focused on, some sheriff's offices are in the municipal system with a 20-year plan, some are in the state system without it. And the discussion focused on switching, and for a lot of technical and practical reasons, that both carries a significant cost.
and provides real practical challenges. So it was something that we were never able to really make happen. Fast forward to 2022, when the legislature passed Act 114, the significant pension reform bill, and Group G was created, largely with the work of Mr. Howard and others. And that group was to solve the sort of concrete problem faced by corrections officers and certain mental health workers who had sort of what you think of as frontline job responsibilities, high stress, high turnover, and it was to provide a retirement plan that could better match the exigent circumstances of that job. So whereas we hadn't been able to find a solution with the sheriffs who were in the state system, once Group G was in place, it provided a really neat way to solve the problem, because in this case, they're not changing systems. They're staying within the state system. The group is designed to be cost neutral. And so all of the practical costs and other barriers that were in place with the state to municipal switch sort of went away. And the state had already kind of, I guess, trod this ground that with law enforcement officers, because our Group C and most law enforcement officers have a 20-year retirement plan. So it wasn't, from a policy perspective, it didn't appear to be something new or different or unique. So we worked with Annie and Sheriff Marcoux for, I guess, since the summer, to really work through the technical details of it and to mirror what we did for the corrections officers and the mental health workers. We gave the one-time choice last summer. So it was a lot of work. Just sort of brag about the retirement division staff, our specialists did a roadshow to all the prisons, all the mental health facilities. They really, in the winter, driving all over the state. I think they did a bang up job making sure that those folks were educated on choice. We were able to manage that successfully. Still ironing out some practical issues that come out on the back end, but I would say largely very successful effort. And given that that was, I think, about 1,000 folks, 900-ish had the choice. Now we're about a tenth of that, and so we're confident that we can mirror that that process with the sheriff's offices. So, and as the fiscal note that you have says, we talked to our actuaries about it and said, hey, do we need to do a new analysis for this? And they said, given the low number of individuals and the proximity in time to the previous analysis, we can be confident that this is a cost neutral solution.
Okay. And the changes that we made in the language, are they?
Today?
Yeah, the in the yellow.
Still have a few concerns about those, actually, because one thing that those would require us to do would be to keep a monitoring system in place for certification.
Sorry, which areas you concerned with? I'm not sure.
Starting on page 2, the language. Do you need a paper copy of it? Or
I can pull it up.
Okay.
Oh, thanks.
Lines 10 through 12, the new language about certification for sheriffs.
Yes. So the way we don't police, if you will, the certification status of individuals. So this the language we have for the deputy sheriffs have attained level 2 or level 3. That's kind of pulled over from our Group C definition. For Group C individuals, there are traditional law enforcement. They have to have level 3. They have to have attained level 3 status. And so and really that's a part of the job, right? You can't be trooper or a game warden without that. So we don't have an ongoing system to report whether or not that certification is maintained. Because if it weren't, I don't think the person would have a job. And because the way it's phrased,
Fortunately, elected sheriffs are different.
Yes.
So we need to create a different opportunity here. I mean,
Precisely. But that's I just wanted to flag the issue. We would need to create a tracking system for certification. While it seems sort of, on some levels, it seems like, well, we just hear about it.
Well, we could put language in that says the criminal justice council would notify you if a certification were revoked or something like that. Cause that's who does it, the criminal justice council
Would notify us. of
would
all that.
notify the treasurer's office.
And then the result, what would the intended result be then?
Well, so here, this is I guess the question is, this is for the one-time shift over. Right now, right, their language is in here twice. Because one is about the permanent status in the group G. And one is about the one-time chance to get into group G, correct? And the one-time chance to get into group G is just a one-time thing. So in order to get into it to begin with, you have to have your level 2 or level 3 law enforcement certification.
Yes, for the deputies as it was prior to this.
Correct. So all we did was add that the same is true for sheriffs.
And that, I think, is manageable. We know at the front end, something that, you know, we know the characteristic
right.
of eligibility.
Right, so then the other stuff, the other language is the permanent language, and it already had and Rick, since you're back in
Yes.
the room. And the language on page 2 is about being in the group G permanently, correct?
Correct.
And so prior to this, you said that level 2 or level 3 law enforcement officer certification from the Vermont Criminal Justice Council. And it says have attained. And my concern with saying have attained is you could have attained it and then lost it. So it was the language was added to say you have to have attained and I had suggested maintained the levels 1, 2, and 3, so that you to even get in, you have to have that certification. But once you're in, there wasn't an intention that you would somehow lose your, but go ahead.
Yeah, so again, Rick Sable, Office of Counsel, keep in mind that this statute's referred to a lot later on, like we're referring back to this, so. And plus, if someone is hired as or is elected as a sheriff after January 1st, 2025, they are put in the group G, they don't have a choice, right? So
Right.
they're in group G. If they have their certification revoked, I'd argue the statute may not be clear. I think that might be Tim's issue, is that how are they gonna be, what should they do if if they're notified a sheriff or a deputy sheriff has lost their level 2 or level 3 certification, it's been revoked, excuse me, what should they do? I think that's gonna be a question we need to have an answer to.
Go ahead, Senator.
Okay, so I would assume in most instances, a deputy sheriff who loses their law enforcement certification would be fired. And they would no longer hold that position. What would happen to their pension then?
If they were fired,
Yes.
Yeah.
it depends. So if they had vested in the pension, had sufficient years, 5 years to vest, we would hold on to it until such time as they either withdrew it or chose to draw retirement at the appropriate retirement age.
But they wouldn't continue.
If they're not working, they would not continue to accrue years of service toward a greater pension.
Right. So
Correct.
for
That's
deputies,
what I would just think should happen
right,
in an instance where a sheriff loses their law enforcement certification it's paused. Because we can't fire sheriffs. But if they were a deputy sheriff, they would be fired.
Oh,
Yeah, they're not like.
right,
No.
is that, so I just wanna turn to Roger. I mean, if for a deputy, if they had their law enforcement certification revoked from the VCJC, they would probably be fired, right?
Roger Mark, yes, they couldn't perform their duties.
Right, so they would be fired if they're a deputy, and therefore they would just stop accruing, as
Right.
Senator Biehoski said.
Which
So-
is what should happen.
oh, I thought the intention was for them to, the language as I read it, I thought, and please, let me just
Yeah,
preface,
no,
I've talked to my operations director and general counsel, and we're still sort of issue spotting through this.
Yeah, that's totally fine.
But I thought the intention was for the G benefit to trip to an F benefit at that point, but it's to stop any eligibility for.
Well, if they're a deputy, we just heard
Yeah,
from
yeah.
Sheriff Marcoux, they would be fired if they got their their certification revoked. So when somebody gets fired, anybody gets fired, they just stop getting their retirement benefits,
Right.
right? And then for sheriff, if they lose their criminal justice, if they lose their certification. Essentially what I think we're saying is they would get the equivalent of being fired. Even though we can't technically fire them, we have to impeach them, and that's a whole other ball of wax. That's another bill.
I would respectfully to read this with that in mind.
Okay.
Again.
Yeah, and so Bob, I will just say, with all the pins in this, we probably won't vote this out today.
on this one.
Okay, but, so we do need to, if you wanna take this back and sort of think about it, and maybe we need to clarify the language to make it more clear, because if you didn't understand it, that's a red flag.
Yes.
It's different. I will say that the idea of ongoing tracking of the certification piece does give us pause.
Yeah.
Some kind of ex ante requirement, less pause. And I have to think about
But it's still, but even before this change, you would have had to apparently do the tracking for deputies.
No, with the deputies, because the new language is that and have not had such certification permanently revoked. So we sort of have if they've attained it, they're in, and we're not tracking it on an ongoing basis. That's the same thing with the Group C, our Group C members. We don't have a system in place.
Except for that they would be fired.
There's a logical sort of other result that compels the.
But if they're decoupled from your system, that's easier for you to deal with than if there's a hiccup in that.
Theoretically, but I'm gonna hold off on saying that.
Okay, Roger, do you have something else to add?
Yes, Roger Marcoux again. With respect to the tracking, Department of State's attorneys and sheriffs could do that pretty easily.
Yeah, I would think.
Yeah, I think the criminal justice council too, like there could be a sort of notification.
They could contact DSAS.
Yeah.
And so, it's not gonna happen very often, so that.
Yeah, I mean, this is not gonna be like, hopefully, not
Yes.
it's not gonna be, this is just in these circumstances where somebody, for lack of a better word, does something bad.
Yeah.
But why don't you mull it?
Go ahead. Yeah.
Now. But Senator Bielanski, because I also have another question for you.
I do, so, and I understand that you don't feel prepared to answer this, but is any addition to Group G going to be cost neutral?
Theoretically, so it becomes, if we were to say. All of Group F is now in Group G, right? Thousands of people. We pause and have a really serious conversation with the actuaries. There was we had that conversation for the cohort that we're talking about in this bill.
Okay.
And they were of sufficient mind that it was any impact was de minimis one way or the other.
Okay.
The reason that I ask is because I have a pretty tough time looking at one group of state governments and recognizing the stress they're under when we have DCF workers that have been in multiple committees talking about the incredible amount of stress and DCF workers that are being murdered. And we're not talking about including them in Group G and talking about the impact that the stress of their job has. So there's an exceptionalism here that feels like it's happening that we're not actually recognizing. And frankly, it feels somewhat grounded in some really sexist spaces because DCF workers are probably more women than our sheriffs are. And so I am struggling. And I don't know if you've looked at what it would take to add DCF workers, but there are plenty of people we should be talking about giving the ability to retire from an incredibly stressful job earlier, but we are focused on one thing.
So better time.
Wait, just a second. Have you looked at that issue at all about what types of professions are in this? I mean, is Group G defined by the profession of being quote unquote stressful?
No, that was the sort of, I think that would ultimately it was a political result, that the Group G was created in the Act 114 bill.
Or correctional officers.
And specific mental health workers who have direct patient contact. So perhaps I shouldn't have said stress, but there was.
It wasn't directed at you, that's the larger conversation.
Sure,
Sorry, can you just clarify who are the mental health workers? I think would be helpful for all of us to understand who of the mental health workers are not.
I would have to go back and get addressed. There's a lot. There's like characteristics in the bill have direct patient contact. I don't have a list of positions on me, but folks
Oh,
that
so they're
work in.
physicians.
Yeah, they're often, I think a lot of nurses that are sort of facing patients who are in state mental health facilities directly.
Like the state psychiatric hospital.
Yep.
Yeah, okay. Go ahead.
So we have this window that I think what I think what we're concerned with, and Steve has figured out for his people, this is, he's trying to get them in under the wire. Our wire, when is the drop dead date for Group G?
Last year.
Last summer was
Yes.
when you did your tour. So I have two questions is, we're opening the Group G in this bill for another limited time.
Yes.
How many people did you get of that 900 to 1,000? How many ended up switching?
Third,
A third of them switched
yes,
from F to G.
correct.
And what, if we don't, could we, I'm just trying to figure out how we can extend this window of opportunity and at the same time compare a state employee who has a fabulous benefit package. I mean, you're right, they can't retire earlier, but they do have a very good benefit package, a retirement package for people who work at DCF and for state's employees. So the chief difference is the retirement age and the service time. Is that right? Is that right, Steve? And Tim, you two know about this better than I do.
Yes,
So to go to Tanya's
And cost.
concern,
you have to pay a lot more.
You have to pay a lot more.
and you have to pay more to be in Group G.
Correct.
But the benefits that currently a person who's working in a stressful job as a state employee, their benefit package is great. It's just they have a 30-year, is that right? 30-year service? What should
Yeah, I went to
Tamsin.
Yeah, he's the.
So for Group F,
But for, who's a state employee who's not in Group F, who's a state employee, they're in some better group, right?
no.
They're all.
So
Group
almost
F?
all state employees, just real quick, almost
Yeah.
all state employees, are in Group F.
Oh,
Our law enforcement is in Group C, our judges are in Group D, and Group G is correction workers and certain mental health workers.
An A and B.
yeah, we're A, B, and
A
E.
and B are relative of years past.
Got it, okay.
Oh, so it's okay, and then.
So it starts, the alphabet starts
As
with
with,
C.
as with E, E was a,
Oh, E?
E was
Yes,
a
makes sense.
non-contributory plan that morphed into a.
Okay, there are no vowels.
That's correct.
Okay,
That's
all
correct.
right, excellent. Okay, so I do think the question of like, we are opening up G beyond the deadline, and we're doing it for a special group. Is there an opportunity to add more people? Or does the door close again and does it close harder?
Well, this body is the one in charge of the door. And so I can only speak to sort of what's happened.
Yeah, no, that's fine.
I can tell you additional complexity, additional movement within the system will invariably create challenges, whether that's, and I would, before going down that road, I would sort of urge folks to kind of think through some of those challenges. So I'll give one, for example, there was some substantial pension reform back in 2008. So I, as someone who started after 2008, have a different benefit than someone who started before 2008. We're sitting next to each other. You know, this person has that thing, that person has this thing. our staff hears it all the time, this sort of dissatisfaction that can come from, well, so-and-so has this, why don't I have this? Because folks don't often understand the nitty-gritty details of these pensions the way, you know, we do in our
Yeah.
office. So there are a lot of real practical concerns that come with switching in this manner. One thing that sort of got us comfortable in this space was the sheriff's offices are a really unique creatures.
Yeah.
Oh, yeah.
So I wanted to tell this committee that, but they may be the only entity I'm aware of that through some quirks of the law had the opportunity to select whether to be in the municipal or the state. Everybody else,
It's weird.
That's
you
right.
say
and
where
we
they
were
go.
there.
Right, I couldn't be in the teacher system, you know, and like,
Well, maybe it has some sort of universal pension system.
yeah. So, that was not it's just
I know.
the complexity.
I understand.
Yeah.
Universal health.
No, that, okay, so what I think, no, go ahead, I'll let you finish, go ahead.
Well, so I guess I would, before, we felt comfortable in this instance because there was this really both a highly unique characteristics. Let's say three things. Highly unique characteristics of the office. The state had already kind of plowed the ground of a 20-year idea for law enforcement, like they do. And it was sort of doable, you know, so we didn't feel like we would get more of that, you know, well, why am I different from this person? I get very concerned about thinking about this as opening a door and without sort of real study for the impacted parties, understanding from DHR about, you know, what are the characteristics of this employee cohort? Is there high turnover? Are there other characteristics that may have justified the action in Group G? It just seems to me Group G was so long in developing, decades at least, that seems important.
Yeah.
To make sure folks kind of really get what's going on and it's a really grounded decision. It felt like we had that conversation with the sheriffs over the last 5-6 years.
Yeah,
And so
okay,
I just wanted to share that perspective.
yes, that's important, Senator Vihoski.
I appreciate that perspective, and I certainly want you to be aware that my frustration is not aimed at you. I also recall, and you may know the answer to this, or Steve may know the answer to this, that when we were discussing Group G, I can't remember exactly when, that there were some statistics around length of time that people were alive after retirement in these fields.
I believe Mr. Howard had those
Yes.
statistics.
Go ahead.
All right, thank you, Madam Chair. So the statistics around correctional officers, the life expectancy of a correctional officer is 59. And the typical our life expectancy, if all goes well, is 77.
Do you have any data around some of these other fields? Because while I hear Senator Clarkson's point that being a state employee comes with good benefits, the stress of constantly being afraid for your life or carrying caseloads of 500 judiciary, that doesn't go away. And the toll that takes and the life expectancy reduction that has is not mitigated by good benefits. I would love to see us look into all of the classifications that should be put in this, but I can't. Like, this is what we do. We're like, oh, look at this profession, generally male-led professions. Let's do something special for them and absolutely forget about all of the women-led professions that are struggling with the same, if not more things, because they're also struggling with the complex structural sexism built into everything. Again, my frustration is not aimed at you, it's aimed at the world.
I hear you. Totally hear you, Madam Vice Chair. Tim, thank you very much for this background. If you could take the bill back to your people and see if there's some clarifying language now that I think you understand your intent. That would be helpful so we could give it to Rick to make sure that you understand. So you really don't want to confuse you all.
Can I restate it?
Yes.
For both sheriffs and deputy sheriffs, the goal is when and if someone loses their level 2 or level 3 certification, the pension, should they remain employed, continue to remain employed in that position, their pension, they'll stop contributing to and accruing service toward any pension whatsoever.
Yes.
Yes, that if it's revoked for bad
If it's,
behavior for, and that if they've had it revoked prior to the switch, they don't qualify for the switch. So they're,
I understand that one.
Yeah,
They
that
would
one-
need to
that
have
one's-
it presently at the time of the switch or when they begin their employment, if they're post January twenty twenty-five.
yes. And that, my understanding, based on the testimony we got from Sheriff Marcoux, is that if it's a deputy and they've had their law enforcement certification revoked, they would be fired, and therefore they would no longer contribute to their retirement because it would no longer be in the job.
Right, I would
So-
probably need to we would probably need to create something in the event they're not, because I don't know that. It wouldn't necessarily happen, right? That would require someone to actually fire them.
Yeah.
Roger Murphy, the bill itself couldn't fire them, they'd have to go through their process that they have a right to with,
Right.
criminal investigation and Laudermill and all of that.
Okay, so, all right, well, let's,
Yeah.
I think that the intent is that whatever happens to the deputies would also happen to the sheriffs.
Yeah.
So if we need to and I can talk to Rick offline about this too, to see, get his thoughts. So why don't the three of us just be in touch about the language?
Okay, I'll get with our.
Okay, committee, do you have one more?
Yeah, my last question is how long would it take to do the type of study and actuarial review that would actually look at all classes of state government who have stressful jobs and theoretically could be in or should be in group G?
Oh, gosh, I don't know that I'd be competent to do the, who has a stressful job piece of the analysis. I think that would be a DHR, that would be something that I would have to receive.
Okay.
So
I mean, DHR.
once, if folks were looking at that and could identify a cohort, then the valuing piece is where I could be helpful, and that would, few months. But I don't know what the front piece would look like.
Understood. I frankly would feel more comfortable getting all of the information about all of the state employees and doing this once than doing piecemeal for certain groups of people.
Okay. Does that include sheriffs? Is that what you're talking about? Just.
I would rather study it all, not do this and do it all at once, because I just don't feel good about stamping some more sexist exceptionalism.
Okay, Senator Clarkson?
I don't feel comfortable with doing that, but I would be comfortable in building into this bill an opportunity for the window to be extended. And do that work, but go ahead with what we've done so far.
I mean,
Really, even if we offered it as a way to keep the window open and review it.
Yes.
Okay. Senator Watson, what are you thinking?
No, I guess this is an interesting new take and I am honestly still chewing on it. I am certainly interested in the more holistic study. I don't know if I am ready to vote no on it, without a study to, well, let me rephrase. I might be interested in including a study that would expand it. It sounds like we need some tweaks anyway to this, so with modifications, I would be fine moving forward, but I do think we should include study to look at including everybody, or who should be, who deserves to be in this class.
Yeah. And how do we define
Yeah.
stress?
Yeah.
Okay. Senator White?
I'm a yes on this bill. I do think that sheriffs are in a very unique position. I think that was kind of the point you were reiterating, is it's not necessarily the job itself in comparison to other jobs. It's the function that they play in relation to the fact that they are so unique as an organization. And they also are a group that previously were kind of able to pick a different pension system, which DCF workers, they're not in that situation. So there are a lot of administrative reasons that I think this makes sense. And I also, well, I respect the point around sexism related to this. It does not go unnoticed to me that this bill was in part mentioned to me by a woman. We have a female sheriff.
We do.
And this is an important bill to her. So I do think that there is, I respect your point. I really do. Flaggers are in a very stressful job too. Literally.
It's not just DCF, what about dispatch?
Yeah, exactly.
What about the state's attorney?
Exactly. So once you open up, could I just finish my point? If you open it up beyond this point, I think that the same case for DCF workers could be made for flaggers, for other things. So I'm not necessarily in favor of opening it up, but if a study would help you, that's fair. I don't think it would, so I don't know if it's worth going down that, but if it would, I would totally be pro. Like to get you to a yes vote, but personally, I'm a yes, and with, it seems like some technical tweaks that we were making, not policy-based tweaks.
Okay. I will hear from you about some potential changes if that, to clarify the language that we fully, you and I should clearly talk a little bit. In terms of the last part of it, Annie and I talked about including a sort of time study for state's attorneys to see if we can get to the right percentages for state's attorneys.
I mean, in terms of pay down today.
Yes, but keeping the sheriff's language in here, but maybe having a little bit of tweaks to that. I do want to note, Senator Clarkson, that we added an intent section. Did you?
And I also noticed where it was.
Well, it's because this is the part of the bill it's about. It's not the intent for the entire bill.
I appreciate that. I love the intent.
Okay, so committee, thank you all very much. We will
Thank you for
take
your
this up
tenacity.
probably again tomorrow.
Thank you for
I'll
your
take
tenacity.
touch. Yeah, sorry.
Thanks, Anne.
So we're gonna, just let Michael know that.
Tim, it's nice to see you.
It's really to see.
Because we really haven't seen you since we do have pensions.
I know, it's, I'd love to come back generally.
Yeah.
But,
Just email me if you have, pardon
I
me,
just want to get your timing and what your expectation tomorrow.
if we can vote it out
I assume
tomorrow.
you already have a list of people. Yeah, so
And-
really it's just a couple months
and
to the
maybe
actuarial study.
Language on this study. But
It's okay.
if we're, I mean,
Kinda what I'm
we're at the end of the session.
We're really
We're
going
rushing through time, so the sooner the better.
I'll give it.
Thank you. Sorry, guys. All right, maybe,
Oh, it's 5:13.
I know, but we had a bill on
We
the
have to
floor
get
for
this
like
done.
3 hours and we are way behind it.
Oh,
So
have
we
an
want
update on that
these
bill?
meetings to, we're gonna shift to H6. We have Michael. Okay, okay, that'd be great.
I guess it's not a statement on the committee itself, it's what you're expecting.
We're gonna vote this bill out and then we'll be done.
Okay.
Wait, I didn't give you here.
With a new version?
Yeah. Well, that we have an app, we have enough of these.
that they started.
Did you guys get?
Maybe, are they on our desk?
Here, no, here, no, they're yours.
Well,
Did you, okay. Sorry. All right, so thank you for your patience, Michael, sorry about everything, but, this is the animal welfare bill. We have just a couple of instances of amendment, and can you walk us through them?
Sure. Working off of the bill as passed by the House. You could go to page 4 of that, you would be in section 1, you could say chapter 190. There is a requirement that in the plan that the director recommend amendments to animal welfare statute and rules, including standards of care for animals housed by animal shelters or rescue organizations. They want those recommendations to say housed or imported by animal shelters or rescue organizations. So that is the first instance of amendment on your amendment on lines basically 6 through 9. The second instance of amendment is on the same page of the House passed version, page 4. It's in subsection C in the directive to the director to consult with state agencies regarding the time that they spent responding to animal welfare complaints. There is a requirement, or in the proposed amendment, there will be a requirement to estimate the number and type of animal welfare complaints received by state agencies. So the language would read, the director of animal welfare shall consult with other state agencies that respond to animal welfare complaints or with animal welfare responsibilities to estimate the number and type of animal welfare complaints received by state agencies and to quantify the amount of time state agency staff expend fulfilling animal welfare responsibilities, including the cost of agencies of fulfilling responsibilities.
That worked, and that's all we did.
And that's additive, really.
Yes.
That, yeah, we got testimony that there's unsure about the data, so maybe it's a chance.
We need
to try to
more
get
data.
some data.
And then the last instance of amendment is on page 5 of the as passed bill. This is the issue I
We
pointed.
only have one.
Nope, this is not.
It's like and.
Right. Oh, you mean it's not on this sheet?
No, right, I mean, for context, for what you're looking at, what the amendment amends is the House passed version.
It's that part, 67.
Okay, and what's our, like, what page?
Right, so page 5 of the as passed by House.
Oh, the 67%, yeah.
Right, this is in the creation of the special fund, when there was the floor amendment and there wasn't that change from 50 to 67.
Got it.
Okay,
Right,
we good with this?
yes.
All right. Thank you, Michael. Are there are no questions? Okay.
Well,
We're gonna. Did you say?
I did not, I didn't either. All of her things are still here.
Okay, do you wanna just see if you can see her in the hallway? If not, we're just.
Who's
our reporter?
We do.
Oh, yeah.
Senator Watson should report this.
This was your baby, honey.
What?
Okay.
No, we're not. Sorry, I didn't get a chance to talk to you. I don't think you need to stay, Michael, unless you want to.
Sure.
So you can head out. Thank you for your work on this. I really
You're welcome.
appreciate it.
Have a good night.
Good night.
Yeah.
You don't have a normal clerk.
If you ask me, I'm happy.